Hello, good afternoon. Now we have the panel dealing with the Faux. In 1993, The New Yorker published a cartoon that became an abiding meme of the digital networked environment. On the internet, no one knows you are a dog. Today, separating truth from fiction, real from unreal, has become a major concern for internet platforms, news organizations, the entertainment industry, and policymakers. What can be done about fake news? And how can recognized news sources prevent their brands from being coopted by it? How can we sensibly fight deepfake pornography in which celebrities, almost always women, are made to appear in online sex scenes? In a future in which actors, both living and dead, can be digitally inserted in audiovisual works, what's the right balance between protecting performers and safeguarding free expression? Are disclaimers enough for a lot of the Faux enough? In a world in which any of us can be the target of an online digital replica, what is to be done? So we have here Professor Justin Hughes, Professor of Law at Loyola Law School, Ben Schaffner, Senior Vice President and Associate General Counsel, Copyright and Legal Affairs and the Motion Picture Association of America, Professor Eugene Volokh teaches free speech law, tort law, religious freedom law, church-state relations law at a First Amendment amicus brief clinic at UCLA Law School, and Danielle Van Leer, Assistant General Counsel, Intellectual Property and Contracts at SAG-AFTRA. Welcome. And I think I missed one.
That's okay.
Okay, sorry about that.
All right, well, thank you. As Fabio said, questionable truths and questionable facts have always been part of the internet environment, but we seem to be living through a new wave of what might be called falsehood enablement. And the faux is increasingly credible, entertaining, disturbing, believable, and often believed. So we are hearing about that increasingly in terms of fake news, deep fakes, digital replicas. So I will also introduce our panelists via some of the issues. So I will introduce the issues and the panelists together, and hopefully get you thinking about these issues. So let's start with a simple deep fake. This is
When there's so many haters, I really don't care because their data has made me rich beyond my wildest dreams. My decision to believe in Spectre literally gave me my ratings and my fan base. I feel really blessed because I genuinely love the process of manipulating people online for money.
So if you think Ms. Kardashian actually said that, she did not, although it looks quite convincing, and it was prepared for an art exhibit in the UK. It was posted online in many places until the Kardashian team got it taken down through a DMCA action. But I'm sure you can find it in some places. Now, if you're like me, there wasn't much before Kim Kardashian's life that interests you. But this surely did, and really got me thinking a lot about deep fakes. Of course, more of deep fake, what we've seen in deep fakes, is the issue of deepfake pornography. And there has been a real explosion of this tawdry, unpleasant, in many ways disgusting little world, in which it is a normal pornographic video is taken and a face set of a celebrity, almost always, 99.9% of the time a woman, a face set is used to construct a convincing facial image to insert over the pornography, to digitally place into it, to create the appearance that the person was engaged in sex acts in which she or he was not engaged. It took me a very, very long time to find a PG-13 screenshot of this world for you, so I want some appreciation for that. There was even a certain amount of cutting I had to do here. And to talk about that, and I believe that's Jennifer Lawrence. Is that Jennifer Lawrence? Yes. Yes, supposed to be Jennifer Lawrence. And to talk about that will be our first speaker, Rebecca Delfino, my colleague on the faculty at Loyola Law School, who is the author of a recent article in Fordham Law Review on this problem. And then, as already during the day, a couple of our speakers have already mentioned here at TechTainment, there's the problem of digital replicas that are now able to replace people in all kinds of roles, including professional roles, the professional roles of actors, the roles of musicians, the roles of newscasters and athletes and journalists. All of us who grew up in my generation subsequent know the Star Wars franchise, and we know the Grand Moff Tarkin who led the Death Star, played by Peter Cushing in 1977. Just a couple years ago, in 2016, he reappeared in Rogue One. Hollywood was utterly shocked. Going around, everyone was saying, what moisturizer is he using? But in fact, he had died in 1992. And to Disney's credit, Disney got the permission from Peter Cushing's estate for the digital recreation of him using an actor playing the role and then digitally creating his face on top of it. But this, of course, raises a huge number of issues in the entertainment industry for actors and for the relationship between movie producers and the acting community. And of course, it's not to say that this is wholly new. Many people will remember in Forrest Gump, one of the tropes of Forrest Gump was that Tom Hanks was inserted in many newsreels in which he certainly did not appear. And presidents, Kennedy, Johnson, and Nixon were all made to say things that weren't quite what they said in the actual newsreel. So to discuss those issues with us is Ben Scheffner, who is Senior Vice President at the Motion Picture Association, as well as Daniel Van Leer, who is Assistant General Counsel in charge of IP and contracts at SAG-AFTRA. I should also mention that Danielle recently finished a dissertation on the issue of revenge porn and digital deepfake revenge porn. And so that is also an abiding issue for the acting community because of the problem of less scrupulous producers less scrupulous than the members of the MPAA, who will sometimes take actors and insert them in situations in which they refuse to appear. And of course, having a president say something they didn't in a fantasy film is just a few steps from having a president say something he didn't in a news clip. And many of you have seen Jason Peele's wonderful rendition of President Obama, in which a real interview with President Obama is digitally altered for President Obama to say many things he did not and would not say, or as he says, I would not say publicly. And that, of course, raises the issue of fake news. And certainly anyone who has written in this space has brought out the issue of, are we in for a wild ride in the 2020 election, given what happened in 2016? Are we going to see a rash of digital replicas being used in fake news efforts? And if you aren't worried about that enough, you should know that the first digital replica newscasters have been deployed by Xinhua News Agency in China. They call them AI news anchors, but they really aren't. All the AI can tell involved might be in controlling the facial expressions. They are literally digital replicas where the people type into the computer what they want the anchor to say, and this news anchor, based on an existing known news anchor for Xinhua Agency who agreed to this, will say anything you want him to say. So these are the issues. Of course, again, that's not news, completely new. We've been dealing with fake news for a long time. Professor Volokh reminded me that only 15 years ago, one of our most eminent newscasters had his downfall because he believed in a bunch of fake documents that were concerning then President Bush and then President Bush's time in the National Guard. And so we have been dealing with this problem of fake news for a very long time. And so to address what can we do, what can't we do, what should we do, we have as our final speaker Professor Eugene Volokh, who is the Gary Schwartz Distinguished Professor of Law at UCLA. and founder of the Volokh Conspiracy, one of the most enjoyable multi-party blogs on legal issues in the United States. So with that, I think I will turn it over to Professor Delfino to get us started on telling us about the problem of deepfake pornography and what can be done, what might be done.
Thank you, Professor Hughes. So I want to first give you a sense of how this phenomenon came about, because it's extremely recent. In November of 2017, a Reddit user who went by the handle of deepfake posted on a forum an algorithm that leveraged existing algorithms in the artificial intelligence space that showed how to create a deepfake. And the very first one he posted was one that was pornographic. I believe it might have been Daisy Ridley or Gal Gadot. Someone in the first couple of days, these are the ones that were posted. And literally it was a pornographic scene, a video with their face implanted or meshed on top of it. And it was extremely realistic looking. It got a lot of traction from other users of Reddit, and by posting the algorithm, then the users of Reddit reposted that algorithm on, I think it was GitHub, which is one of the major free code sharing sites, and it exploded from there. And by January of 2018, someone had developed an application that one could download onto a smartphone called Fake App. Now you're saying, well, Daisy Ridley, Scarlett Johansson, she's another favorite of the deepfakes. What does it make any difference? Most of us aren't those people. The concern is, however, that any person who has a digital image anywhere, whether it's posted on your private computer, on your phone, on Facebook, anywhere in social media, if you have an image, it can be taken and used with the application, and you can star in your own deepfake, pornographic or not. And then the next question becomes well, how harmful is that? We certainly know it could be widespread because it could happen to any of us who have digital images that have been captured, whether they've been shared or not. The harms in this space are very similar to the harms that people experience when they are victims of revenge porn. And typically, those harms are emotional distress, reputational harm, harm to one's ability to apply for and secure a job, harms that affect a person's emotional well-being. They're harms that are relatively hard to quantify and monetize, but they are certainly real. So much so that the Cyber Rights Initiative Project surveyed people who had been victims of revenge porn, which is, again, very similar, and found that more than 50% of the victims had either suicidal ideation or experienced some significant emotional and mental impairment that required either hospitalization or medication. That's more than 50%. Another 40% of those individuals believed that they could prove that they had suffered career or reputational harms. And so those are real and genuine harms that, as I mentioned, because if you have an image, you can be a victim, any one of us could experience. So then that leads us to the next question. Isn't this illegal? Can't I sue someone? Interestingly, as of this afternoon, when I left the law school and I checked, there is currently no criminal statute. There's no crime. There's no civil tort. There's no civil remedy one could seek if they find themselves a victim of a pornographic deepfake. And I say that because I checked this afternoon, because in California, there is actually a bill sitting on the governor's desk right now called AB 602, which seeks to create a civil tort, a civil action for the production and distribution of deep fakes. So it's out there, it hasn't landed yet, and the governor may sign it. But in the meantime, there is no civil remedy, nor, as I mentioned, is it a crime. Now, the closest comparison is in the context of revenge porn, which I mentioned, and there are now 44 states that have laws that criminalize revenge porn. There's no federal law that's criminalized revenge porn. It never has made it out of committee, though there have been a number of proposals. The problem with revenge porn laws is they don't exactly fit to this particular harm. So revenge porn laws exist where someone has either given their consent or in the context of a consensual relationship, had a photograph, an image, a video taken of them engaged in an intimate or sexual act. And then later, someone gets access to that video. It's typically a former intimate partner, and then that person then posts that image or video on the internet. And that is essentially what the crime is. The reason that doesn't work in this space is that it is premised on the idea that the image is real, right? That there is one identifiable victim. And that is actually written in most of the revenge porn laws. The other part of revenge porn is that it relies on this notion that the person whose image was taken and posted had an expectation of privacy in that image. Now, in the context of deep fakes, how does that exist? Who does that expectation of privacy belong to? Now, you definitely have an identifiable, perhaps, face of the person, but then you have a body, and we don't know who that person is. And maybe that's not a real person, right? That could be an avatar of some sort. So there are issues about whether the revenge porn laws will work. And there are no other criminal laws. All the other criminal laws, cyberbullying, cyber harassment, all the other child pornography, all of the other criminal formulations that currently exist, again, have some of the same challenges. So then that leaves you to question, well, what can I sue someone? Now, in terms of suing someone, again, there are different civil actions that one could think about. Appropriation of likeness, false light, defamation, those sorts of things. And while some of them might work, because especially with false light and defamation, there is this notion that the thing that's been put out in the world is false, right? So there's the falsity piece. But the concern about all civil actions is that civil actions often are inaccessible to folks who find themselves victims. And I say that because, number one, if you're going to sue someone, you have to find them and serve them. And the perpetrators of deep fakes are often anonymous, and maybe they live across state lines, right? So there's that piece. There's also the concern that you have to prove damages. And as I mentioned, it's really difficult to prove these damages. They're real, but they're hard to quantify. The other problem with civil law is the fact that in order to sue someone, you have to, in general, hire someone to do that on your behalf. So you have to pay a lawyer. You have to probably engage in expensive discovery. You may have to retain an expert who can help you prove that that's actually you in the video. And many folks that might find themselves the victims of deep fakes don't have the resources, up front at least, to pay for that sort of legal representation. So while civil remedies might work, there are definitely barriers that exist in the access to justice space for the people who may find themselves as victims. So the takeaway is that there is currently nothing that one can do in terms of going to court and getting relief from the harms that are unleashed from being a victim of a deep fake.
Okay, that's a cheery note. And I want to move from that. Rebecca already mentioned AB 602 in California, and I know Ben and Danielle, you both know that quite intimately. But let's turn to the general problem of what do we do about the new frontier of digital replicas of professional performers? And how do we see that playing out? And I will recall a couple decades ago, and this is why you shouldn't say things when it's technologically based and you don't know. I remember a former president of SAG-AFTRA, Richard Mazer, who said, I'm not worried about digital replicas or avatars because they won't be able to do press interviews and they won't be able to do red carpets. And of course, I'm sure there will eventually be digital red carpets and there will be digital interviews and we'll create digital lives for our avatars too. So what do we do in this new world where it is a technology that has tremendous creative potential, but it also creates tremendous risks for performers? And I welcome either of you to start. I didn't pick which one of you are going to start.
Yeah, I mean, I think it's interesting, and I just want to preface that my opinions don't necessarily represent SAG-AFTRA's because I actually have more, I would go further than we do on some of it. And as I was talking to Professor Delfino before, and Professor Hughes mentioned my dissertation on deepfakes, which I was studying it from the EU perspective and UK-based, and they're much more respective of individual dignity and privacy over there and the balance against free speech than our law recognizes. So I just preface that to some extent it doesn't necessarily reflect the organization. But does anybody watch Black Mirror? Anybody see this season of Black Mirror, the episode with Miley Cyrus, where I see Tracy back there, where, you know, Miley Cyrus, her character was basically drugged and put into a coma by her manager and replaced by a hologram. And, you know, as the more you read, just in the course of doing my dissertation, this technology for deepfakes, this was in several months, the technology grew exponentially. So, I mean, I'm not saying that that managers are going to drug their clients and replace them with digital avatars, but you know, certainly the technology is there to replace performers. You know, we see the Grand Moff Tarkin example. There still was an actor playing the role, and then the technology overlaid it. But what's happening now is deepfakes, is this deepfakes technology, and we can, I'm not going to parse what a deepfake is versus some of these other technologies that are being used, but they're making it possible for the independent filmmaker creating web series in his you know, home studio to do what Disney spent millions of dollars to do, and to put people digitally into their works. So for us, there's for the organization, there's a couple of different concerns, and one of the big ones is, one, you know, simply digitally replacing people in their work. Digitally replace broadcaster, for instance, takes jobs away from people. And as a labor union, you know, one of our big concerns is our members' ability to earn a living. And one of the other big ones, and it goes more to the points that Professor Delfino was making, is the potential for unprecedented, unauthorized nudity in films. We have strict rules on when nudity can and can't be used, and under traditional filmmaking techniques, there's, you know, different ways that it's not as seamless, but now you can just graft an actress's head onto it. And the stories that we hear, I mean, that's career ruining for an actress. We had a panel at the Guild a few months back on this topic with Congressman Schiff and a couple of researchers, Hani Fareed from up at Stanford. And we had an actress on the panel who was telling us the story, and this was under traditional filmmaking techniques, where she did this movie, a PG-13 type movie, where she, you know, no nudity, she didn't consent to any nudity, she didn't do any nudity. Independent producer was having trouble selling this film, so he decides, without consulting with her, without getting her consent, he decides to go add in a sex scene and has some body double do this scene. Of course, you know, sex sells, and the film suddenly got distribution. And he calls her up, he's like, hey, we got distribution. She's like, oh, that's great. He's like, yeah, we added this nude scene, we didn't think you'd mind. And she was like, wait, what? Of course she minded. It wasn't the image she had for her career. It hurt her career. Her remedies are limited in that regard. And with deepfakes, the potential for that just skyrockets, and the potential for doing it believably. Because when you're digitally when you're physically doubling somebody, they do different techniques like shoot from behind. You don't necessarily see the person's face in the midst of these scenes. Even that film Nymphomaniac was an example that I used in my dissertation, where Lars von Trier with Shia LaBeouf and a couple of other people, they shot actual porn actors actually performing sex, and then use filmmaking techniques to kind of graft the actors onto it, fully with consent. But could you imagine, the actors being put in that position without their consent, being doubled onto it? And deepfakes puts that technology even in the hands of, basement filmmakers. And that's where some of our concerns come from, and that's where a lot of the concerns that led to working on sections AB 602 came from. And to Professor Delfino's point about remedies, there's always going to be the concern about not being able to find plaintiffs defendants or defendants being judgment-proof. But one of the things that we did manage to do in connection with damages is that it does have very severe statutory damages when it's willful. So like in the revenge porn context, or when they knowingly do it, knowing the person objected to it. So that's one of our big concerns right now with just how that growth is going to affect our members in being put into situations, both taking away their work and being put into situations that they didn't consent to or wouldn't have consent to, that can have in potential career and personal ruin.
And Ben, what's the studio's perspective? Where do we draw the line on how this technology can be used creatively and intelligently, and where do we offer protections?
Sure. Well, first of all, thank you for having me. It's an honor to be here at Loyola. So this is an endlessly fascinating topic. We debate all these hypotheticals internally. We discuss them with our friends at SAG-AFTRA, both in the context of digital replicas or digital avatars of actors and this deepfake scenario. One thing I want to say, and this might sound contradictory, although I don't think it is this problem, especially on the digital replica side, is both hypothetical, largely hypothetical, and it is nothing new under the sun. And by largely hypothetical, here's what I mean. You showed this prominent example from Star Wars, one of the new Star Wars movies a couple years ago, showing Peter Cushing, who died almost 30 years ago, I guess. As you correctly stated, that was done with the permission of the heirs. Another of the most prominent examples in the last few years was Paul Walker, who was an actor in several of the Fast and Furious movies. He died in the middle of production of the seventh Fast and Furious movie. And again, with the permission of the family, the studio created a digital replica of him and used that in a few scenes. So all of the previous examples, at least from any mainstream studio that we represent and any of the mini majors, have all been with the permission of the heirs when it's done. And there's certainly no instance where a digital replica has been made of a living actor and placed in a mainstream movie without his or her permission. And there's several reasons for that. One is, I think there is uncertainty in the law. Whether certain right of publicity laws or related laws would cover this kind of thing. I think there's ambiguity in the law. The others relate to business practices. Talent in this industry has a lot of power, and studios need to keep talent happy. A studio will all of a sudden become extremely unpopular with talent the first time they use a digital replica either of a living actor or even a, say, relatively recently deceased actor without his or her permission or the permission of the heirs. And what you, Professor Hughes, mentioned a few minutes ago about what Richard Mazur may have said a couple decades ago is actually still very true today. studios spend a lot of money and expend a lot of effort in marketing their films. A big part of the marketing is having the major stars show up on the Ellen Show and Jimmy Kimmel and all the morning shows and all the rest. Although it may be theoretically possible today, or certainly in the relatively near future, to have digital holograms of actors show up on those shows, that doesn't happen today. They certainly can't respond in real time to questions and answers. Studios are not going to build movie projects around using digital replicas, digital avatars of either living or deceased actors. And third of all, I just don't think that's what audiences want to see. Could there be times when a digital replica makes some sort of cameo and it's kind of cute, just like President Nixon, President Kennedy, and Johnson might show up for a small scene, which was done. All those were done without the permission of the heirs of any of those presidents. I think the studio pretty clearly felt that they had a First Amendment right to do. But again, there's a lot of business practices and sort of practical considerations that have led to that have prevented studios from ever doing this, even if they had some sort of desire to do, which again, frankly, they don't. So it's largely hypothetical, and then just to sort of fill out the rest of my statement from the beginning about nothing new under the sun. There have been, it was interesting, Professor Hughes, when you introduced the panel, you said, there's been falsehoods and fake news since the beginning of the internet. It actually goes back quite a bit from the beginning of the internet.
Wasn't all truthful before the internet?
So just to focus a little bit more, there have been fake photographs and fake films going back since pretty much the invention of photographs and films. There's been Photoshop around for at least 20, 25 years. People have been able to take pornographic pictures and stick the head of their ex-girlfriend or a movie star on them as well. And have those resulted in upsetting situations for both famous and not so famous people? Absolutely. Are there remedies under existing law? At least in certain circumstances, I certainly think defamation, false light, in some circumstances right of publicity, in some circumstances copyright infringement, et cetera, can provide remedies. But again, these kinds of problems, yes, there's new technology, but I don't think that the ground has fundamentally shifted just because this stuff is a bit easier to do than it was in the past.
Well, right. I definitely want to come back to that, because one problem with deep fakes is that one problem for false light and defamation is if the deep fakes say, this isn't Jennifer Lawrence, but lay back, watch, and imagine, then we have a real problem for a lot of our laws. But let's, before we get into Q&A and back and forth, let's talk about fake news. And Professor Volokh, I'm scared to death of Xinhua news anchors telling voters that there's a curfew the night before an election, and laying out reports of all kinds of new National Science Foundation studies that are completely bogus, but that reinforce racial or gender stereotypes. So I'm very worried about an explosion of fake news. So what might we do from a First Amendment perspective, both as you understand the law and as you would love the law to be?
I do think it is important to keep an eye on how things have been in the past. We're in a very nice place, but we're on, I think, was it Waterfront Avenue? Right, the address here is Waterfront Avenue. Lots of things are said that are not quite true. By and large, people don't fully believe them. We are in a film and television school. The whole point of much filmmaking is to create a lifelike fictional environment, right? Now, much of the time there are cues that inform people, at least at the conscious level, that this is fiction, although often people absorb some of it as if it were fact. Probably a lot of people's knowledge of the past comes more from historical films than from actual history. If you want to go back to history, we saw the We saw the Rathergate memos, but it goes back further. 1876 election, apparently, there was a major role played by a forged letter, ostensibly in the handwriting of then candidate James Garfield. This is a Jesuit school. It's in the Catholic tradition. Well, go back to the donation of Constantine, where during the Middle Ages there was this document supposedly from the Emperor Constantine giving his empire to the papacy. And it turned out it was false. People sort of, I read the short article about it, like people were talking about how it was false from 1001 AD. That was the first time people started talking about that. And then eventually by the 1300s, it became quite clear that it was. So it was a tool that was used for centuries. Forgery is a very long-standing concern. Now, to be sure, documents are not as vivid as video. But at the same time, documents, especially in the past where documents were rarer, often had a compelling quality to them. I've been studying situations where people forge court orders and send them to hosting providers, send them to Google and say, could you please remove this website because this court has found it to be infringing? And a couple of times Google, a very sophisticated corporation, was duped by it and actually took down things because it looked like a court order, therefore it was. So this is part of a very broad issue out there. And now, one could be extra concerned when something looks like a real person doing something. That there's no doubt that that creates an extra level of risk that people will believe it. But I think that ultimately, there's little that can be done about the distribution of this sort of thing. You could, in principle, try to either sue. In certain situations, there would be defamation. Not likely to practically affect things in a lot of situations. You could, in principle, possibly criminalize that kind of thing. And that's an interesting question. To what extent do we trust the government to criminalize false statements? In a sense, the Sedition Act, speaking of nothing new under the sun, the Sedition Act was about trying to criminalize knowingly false statements. So there are possible legal remedies. It seems unlikely they will do much to solve the problem. I think the solution is, to the extent there is a solution, is the same thing that people have been doing for centuries now when they're dealing with non-video falsehoods, even very credible seeming falsehoods, which is you try to get people to be more skeptical. You try to get people to, when they supposedly see President Obama saying something or other, they would turn to some trusted source, and part of the problem is there are not a lot of trusted sources, and some formerly trusted sources have done a great job of losing the trust. But go to some trusted source and see if they say, yes, indeed, we talked to him, we showed him the video, said, yes, that's exactly what I said, or whether this is something that's a fake. That's, again, something that has had to be done with regard to news accounts, with regard to documents. It will have to be done with regard to audio and photographs and video. So I'm not sure there's anything terribly new when it comes to fake news. Fake news in the non-video sense has been a problem that American law has tried to, often unsuccessfully, deal with for literally over 2 centuries, and the laws of other countries even longer. I think ultimately developing and cultivating people's skepticism, coupled with maintaining and trying to rebuild the trust in some media institutions and other such institutions, is the only way of dealing with that. Now, if I could speak a little bit, though, returning to what we were starting with regard to the deepfakes. So I've been thinking about this. I haven't been writing much about this. I'm glad people are. I've been thinking about this for 15 years now. In 2005, the second edition of my casebook, I had a problem that's all about what today we'd call deepfakes. And the hypothetical was somebody would write a program. I used to be a computer programmer, so it's pretty clear to computer programmers that this was on the horizon. We just didn't know when it would happen. Someone who wrote a program which would allow people to take a video and merge anybody's picture. It could be a picture of a star, it could be a picture of a neighbor, it could be anybody's picture. And run it and merge it. And what can be done about it? And one of the things that I was trying to prod my students is into thinking, is there some insight at the heart of the obscenity exception, which many people have been quite skeptical about, in part because it treats sexually themed expression differently from other expression. But is there some insight at the heart of it that suggests that, yes, sexually themed expression really is different? What about the right of publicity, which seems to treat commercial uses of another's name or likeness, generally speaking, sharply differently from non-commercial? Should it matter if people are distributing these materials commercially or not? So it's trying to get, there was no answer, this is a problem in that casebook. It's trying to get people to think about it. The final question, though, was imagine that the government, instead of trying to ban the distribution or the sale of these videos, decided the only thing it could do was ban or distribution of the sale of the program. Because ultimately, if you say you can't, it's a crime to distribute the underlying videos, what will happen is people will say, well, I still want to see the video, I'll just get the program. There'll be sort of an extra user-friendly version of the program. It's going to require 2 video streams, one porn video and one with a picture of somebody from a movie or something like that, so you can transpose it, and then you'll run it in your home. So you could imagine an attempt to do that. You can imagine a full-on war on deepfakes, the way we've tried with the war on drugs, except it would be even harder because, of course, these programs are infinitely reproducible and would be available from a wide range of sites on overseas or not. You can imagine a blacklist, like a Great Firewall of China that Google would have to enforce to try to do this. But my sense coming out of all this is, well, there are perfectly plausible legal arguments that the distribution, and especially commercial distribution, of deepfake porn could be restricted, whether under obscenity theory or a privacy theory or a right of publicity theory. Ultimately, there's going to be all of this stuff. Now, maybe the answer is it's not as much of a problem if people just watch it at home. And everybody knows people are watching it at home, but it never actually ends up in a Google search. But that stuff will be out there unless you take really, by American standards, quite extraordinary measures to try to ban the underlying technology for the manufacture of this technology that is already apparently widely available.
Right, but let me go back to Professor Delfino. There might be a dramatic difference in the dignitary interests, the assault on dignitary interests, and the assault on your personal sense of self, knowing that, yes, 10 million homes have this deep fake app program at home, and they may be making videos of me, and I don't know, versus Scarlett Johansson seeing
Right,
58.
maybe you could say, okay, that's fine, good enough, close enough for government work. Close enough for government work.
Right.
That is to say, banning the distribution might do enough to solve the problem, that the remaining stuff is just sort of the inevitable unpleasantness of life that you will have to make your peace with.
And I certainly agree with Professor Volker. I think, though, the fear that it reaches others that can't, that have no platform to respond, and that it will be used to harm someone because it is posted is genuine. And it is truly different than the other things that we've experienced in the context of manipulating documents or manipulating other images that may have been in the entertainment space. And so there's still this concern for the average person who suddenly finds themselves on the receiving end of this, that they simply don't have any remedy that's accessible to them. So,
Yeah.
Sorry, I was just going to say, Professor Delfino, in your original comments, you mentioned all the impediments to enforcement through civil litigation. I think those are absolutely correct, but I think one that you did not mention, which is I think is the overlay on anything that we could possibly do about that issue, is Section 230 of the Communications Decency
that's right. I was
Act.
trying to stay away from that. That's an entirely additional hour. But if
Yeah, I mean, well, I'll try to.
Yeah.
I'll try to condense it to 30 seconds, but. Even if we could agree that there's some category of videos that are totally outside the bounds of the protection of the First Amendment, and we've written a perfect statute that says, okay, these things violate this law, they constitute a tort, or even a crime, we still have the problem of this federal law called Section 230 of the Communications Decency Act, which says that the hosts of material posted by third parties are almost absolutely immune from a claim, including if I was the victim of a deepfake and I sued the perpetrator and I won my judgment under AB 602 or some other law, and I got a nice piece of paper, I got a judgment, and I got this piece of paper which said this video is totally illegal under this law, and I took it to Twitter or Facebook or YouTube or whoever was hosting it, and I said, hey, I have a court that said this thing is totally illegal, pretty please take it down. Now, they might, if they're good corporate citizens, but they could also say, sorry, there's this thing called Section 230 of the Communications Decency Act, and we have absolutely no obligation whatsoever to do anything about it. So states...
That is an issue, and that is one of the concerns with state law. So one of the things that
it would apply to federal civil law as well.
But not criminal law.
No, it wouldn't apply to federal civil law if the federal civil law is enacted after Section 230 and says this isn't governed by Section 230. It's just a statute.
That's true.
It could do that, yes.
But so that's one of the challenges.
Having a tough time.
Yes, it certainly has, and so that is one of the reasons, especially when you understand, as we all do, that the internet is not fixed to any particular jurisdiction, and that images made of deepfake made of you in China can travel all around the world very quickly. The notion that a state law would be the be-all, end-all of any remedy is challenged by 230. So there is an issue with being able to enforce it, and so I've advocated in my piece for a national federal criminal statute. So.
And I worked on the Hill around the time when the Communication Decency Act as a whole was being challenged. And this wasn't what was in mind when they wrote Section 230 at all. Section 230 was a response to internet message boards and a internet operator being held liable for a defamatory statement that it didn't take down. It didn't contemplate websites soliciting this kind of content. So, I mean, I think the courts have just gone way far in the other direction, and I hope either the pendulum swings back or that Professor Delfino's proposed criminal law starts taking off. But I do want to address Professor Volek's comment about going after the deepfake technology as opposed to the distribution. I mean, I don't think anybody... Well, I'm not going to say they don't care, but I think what you do in the privacy of your own home is not what's going to cause the harm either to our members or any of these victims, usually. There are situations, but I see it more like the Betamax situation. You know, place and time shifting your videos, you know, it was a useful tool for things, whereas, you know, the deepfakes technology is even more useful in a lot of ways. It has a lot of legitimate uses for it. So I don't think anyone wants to really, well, anybody who's really talking about it wants to ban the technology. I think we're talking about the distribution of it and the distribution of this content. And one of the key differences, you know, I mean, I've been doxxed before, and a lot of victims of deepfakes are doxxed at the same time. And for anybody who doesn't know what doxing is, it's when you have your personal information put out there, often by an internet troll. I've been cyber stalked, you know, I mean, it's horrible. But, you know, and I've had situations where I'm pretty sure somebody I knew online was probably doing things with my photos that I wouldn't have wanted them to do. But as long as it's not getting out there, it's not going to harm me. And I think that's where the difference comes, you know, in the speech is, you know, what you do in the privacy of your own home, it may be disturbing and troublesome, but it's not going to have the same impact and harm, especially to, say, an actor or even, you know, us as legal professionals. If, you know, I was just sent a picture of that a company put up on, and this was a real picture, some woman applied for a job and had on her social media kind of a skimpy picture of her in a bikini. And the company posted this up on their Instagram. I don't think they didn't expose her face, but they basically said, if you have pictures like this, don't apply to us. You know, and you take that into the deepfakes context, and, you know, there already was a case in, well, there was one in the UK that I came across in my research where a woman refused to go on a date with a guy. He decided to doctor up some photos of her as was a coworker, and she was like an intern. And so he decided to doctor up some photos, put them up on a porn site, and then reported her to HR. And so she got hauled into her HR, you know, having to explain to them, this isn't me, having to prove to them, this isn't me. And fortunately, the UK was able to, because it was an ongoing course and pattern of practice, they were able to convict this guy under harassment theory. But, I mean, that's where this technology starts to go too far, I think.
So if I could just respond, because I think this is such an excellent illustration of where the new meets the old. On the one hand, there are no question, there are new things that before was very hard to do. There weren't a lot of forgeries from, as best I can tell, from 200 years ago, which actually had convincing pictorial images that one could use just because of the nature of the technology to suggest, oh yes, this person did it, because all you could do is a painting, which is no evidence at all. So there's no doubt that there are some differences.
Some paintings have been forged.
Pardon?
There was a painting of,
there are
I
certainly
believe,
paintings
Lincoln, where it
forged
was a body
documents,
model.
but the thing,
I want to get to some Q&A. So
right, but let me just point out, the thing that you're talking about is as old as the Bible, and doubtless much older than that, which is somebody trying to get back at someone else by accusing them of something that they didn't do. Now, this instance, it was accusing them of posting a sexually themed picture, but it could equally be accusing them of having attempted to rape them, or having attempted to grope them, or having stolen money from them, or whatever else. So the particular scenario that you were describing, which is someone deliberately lying about someone else, about some supposed misconduct, in this instance it was misconduct that had a photographic dimension to it, but very often there are both accurate and inaccurate allegations of misconduct where it's enough to ruin someone's life that there just be a verbal accusation. So that's why I'm saying that a lot of this is not terribly new.
one thing that is new is that it doesn't require an accuser anymore, because if properly done, the accuser disappears into the background, and the deep fake photos or the deep fake video, which we've seen deep fake videos of people stealing from convenience stores that they were never in, and if properly done, the reason I'm pushing you is there's no accuser anymore. It's you're out to ruin someone in a way that you can do truly anonymous.
So absent deepfakes, you send a message to HR saying, here, I'm an anonymous person, or even I claim to be a real person overseas. Here is this horrible racist message this guy sent me. Many in HR is going to come in and sort of assume this person is guilty, and then he's going to have to explain, no, this was not actually something that I wrote. So the question is, to what extent will HR departments be credulous, and to what extent they'll be skeptical? Can
I respond, Justin, real quick?
Well, real quick, I do. Let me have some hands. Are there questions out there? We can go on and on. I see a gentleman in the back. Danielle, very quickly.
Well, yeah, just a quick response to that. To Justin's point about the accuser disappearing, what's happening in a lot of these situations is the stuff goes up. It's nobody going to HR and saying, hey, this person said this, hey, this person did that. The content's up there, whether it's real or fake, and it becomes the first thing that people see, or one of the first things that comes up in Google results. And what happens is, any employer worth their salt is going to search people's social media. They're going to search their online presence, and it just becomes a part of you that you can't get rid of. I have, there's somebody else in Holland that has the same name as me, and she was on one of those like adult dating sites, and that was coming up with my name. Now you could see it wasn't me because there's pictures on my bio and stuff, but one of the first results coming up is someone's adult dating site, and that's going to be forever associated. It's gone now, but that kind of stuff becomes forever associated with these job candidates, with these actors, et cetera.
There's a distinguished gentleman in the back who had a question. He was waving his hands around.
Yeah, so I'm hearing from the panel that American law is pretty much impotent to address a lot of these problems. And I'm wondering whether you might count on Europe to save us, just as we did with privacy law, the GDPR applies to big American tech companies. Today there was a ruling out of the European Court of Justice which eliminated the safe harbor for large tech companies. It applied worldwide, so it will apply to U.S. tech companies as well, and the .com platforms.
That was on defamation, correct? It's a safe harbor on defamation.
But, once you open that Pandora's box where Europe is going to start holding American companies liable for violating European law, I wonder if that's something that ought to be brought into the equation.
That was my dissertation topic.
But Ben, let me ask you, as the large studios watch this around the world, do you see other jurisdictions grappling more quickly than the United States with digital replica issues?
To be honest, I have not heard of other jurisdictions specifically targeting this issue. I will say that overall, I think there's essentially two reasons why the U.S. motion picture industry dominates throughout the world. One is I think we have strong IP protection, but the other is because of the First Amendment, and we have the freedom both to tell the kinds of stories we want, including controversial ones, but also employ new technologies and new movie-making techniques that might be controversial. But because of the legal systems and the protections from the First Amendment that we have, we're able to experiment with those. I mean, I think Danielle made a really good point a couple minutes ago about the positive uses or the benign uses of this technology. And just in preparing for this panel, I just did a little Google searching about sort of what, how easy is it really to create a deep fake or a digital avatar of somebody if you'd like to. And just a couple on the first page of results. There was a service, a website, where you can essentially put in your own image and it'll create a digital avatar of you, and you can choose which dance moves it has you do. All sorts of different, new dance moves. Obviously a totally benign kind of thing, but essentially the same kind of technology really that's used to create these fake porn videos. Another one was just audio only. You could essentially speak a sentence into the microphone. It takes that and runs it through its fancy computers, and then essentially uses that to, you can then type in anything or just put in text, and it'll read it using those snippets of your voice, and it sounds exactly like you.
Right. That's a Canadian technology, I think. But one interesting thing on the GDPR you mentioned is we don't know the full scope of how privacy laws may be used in the digital replica space. And probably everyone's saying, well, you're talking about privacy laws because these pictures of people are not private at all. But there's actually a genuine question under one American law, the Illinois biometric law, as to whether lifting the biometric information on faces without authorization would be a violation. And I've heard at least a couple GDPR scholars or commentators raise the same issue in relation to that. Go ahead.
I wanted to mention, I wanted to respond with actually
Eugene.
a very specific example, something that just was corresponding with this Northern Irish blogger about some demands that he'd gotten. Apparently, somebody in India took a picture, I believe, of Narendra Modi, the prime minister, and some other official who's sort of seen as one of his lieutenants, and created this obviously doctored, there's no question that it's doctored, it's a shallow fake, a picture of the two of them in swimsuits embracing sort of in a vaguely homoerotic way on a beach. So some people posted it just because that's their way of criticizing Prime Minister Modi. Some other people posted it because they were writing an article about this whole phenomenon. So this police department, I've confirmed that it really is this real police department in one of the Indian states, is now sending demand letters to WordPress. BuzzFeed actually had gotten some as well because it had published something about it, and to individual bloggers essentially saying this is a violation of Indian criminal law. And this blogger got in touch with me. I then wrote about it. They haven't sent me a demand letter yet, even though I've posted up the same thing. But his view is no, he's not going to do this, and he's very happy that WordPress isn't going to do this. Maybe the solution is we need to be to make sure that we have our material hosted by American companies that don't have much of a foreign presence, and maybe at some point there'll be pressure to have more search engines which are American hosted, which don't have much of a foreign presence. Because what the supposedly benign forces in Europe might be trying to do, certainly India could do, Turkey could do, Saudi Arabia could do, China could do. So to the extent that it is accepted without any real pushback from the American government that foreign speech restrictions could then be imposed on, essentially in effect on Americans, then again, either we have to act diplomatically to try to stop that, or we have to start deglobalizing a lot of the software that we use.
Right, and deglobalizing might be, instead of having a ubiquitous fake app that everyone can use, having a ubiquitous geo-blocking app so that you can block the IP addresses if you're a blogger and say, I don't want this available in Punjab.
Well, but a lot of people would like things available in Kashmir, let's say, that are contrary to the views of the Indian government, or in Saudi Arabia that are contrary to the views of the Saudi government. But what's more, I thought that the question suggested that it's good that many European countries are now talking about, and this decision seems to authorize, they're essentially demanding that it not just be geo-blocked overseas, but that it be totally blocked overseas. That, it seems to me, is not a step forward.
So we are at the 2-minute mark. Are there any more questions? Yes, real quick. Under 1 minute, and we'll get you a 1-minute answer. So the question is, does the sex trafficking exception that was built into 230 now, and I think it was passed last year or the year before, which basically has now made it clear that Craigslist cannot serve as a site for sex trafficking, could that be used in any way against deep fake pornography?
I don't think so, the way it's worded, but I think it does set a precedent for it, for a narrow carve-out. And to the point on the EU, the EU is already starting to carve out things more than we are, so I do think that there is potential it's not going to change things in the EU, but I do think the EU is a good source of potential guidance going forward for how to do that.
And I would just reflect on 230 that 230 has been very broadly applied, and so I expect any exception to 230 to be narrowly applied.
And with that, I'd like to thank our panelists and thank everyone for being with us today.